Good morning, good afternoon, everyone. Welcome to the third session in our panel series on the law and evidence on self-managed abortion. My name is Heidi Moseson. I'm an epidemiologist and senior research scientist at IBIS Reproductive Health. And I'll share some introductory information before I pass it along to Patty, who will be moderating this panel. Next slide. We, that is Lucía, Berro, Pizzarossa, Adrian Garashi, Farah, Diaz-Tello, and Patty Skuster came together to put together a series of virtual discussions with experts on how the law and empirical evidence on abortion relate to each other across disciplines and in different countries around the world. The series is co-sponsored by our respective organizations. On this slide, IBIS Reproductive Health, If, When, How, Lawyering for Reproductive Justice, the O'Neill Institute for National and Global Health Law at Georgetown Law, and the Temple Law School and the Center for Public Health Law Research. Next slide. So this today is the third in our series that looks at law and evidence on self-managed abortion from different angles. So stay tuned for the fourth and final panel, probably early in the new year, during which we'll talk about new directions for self-managed abortion. Information on the series and recordings for the first two panels are available online. We can put a link in the chat on where you can find the information on the earlier panels. So now I will hand it over to Patty, our moderator for this session.
Thanks so much, Heidi. I'm Patty Skuster. I'm visiting professor at Temple Law School and your moderator for today. Today in this panel, we're looking at legal risk and really just considering the question, what legal risks are associated with self-managed abortion and how can we address them? I'm particularly excited about this panel. We have three panelists and friends and really from whom I've learned so much about self-managed abortion in the law throughout my career. So this is particularly exciting for me. First up, we have Joanna Erdman, a professor and MacBain chair in health law and policy at the Schulich School of Law at Dalhousie University. Joanna has acted as intervener before various constitutional courts and international bodies. She chairs the Global Health Advisory Committee of the Public Health Program and serves on the advisory board of the Women's Rights Program at Open Society Foundations. Joanna is also a past chair of World Health Organization's Department of Reproductive Health and Research, Gender and Rights Advisory Panel, and she holds a JD from University of Toronto, an LLM from Harvard Law School, and has completed a fellowship at Yale Law School. We also have Farah Diaz-Tello, Senior Counsel and Legal Director for If, When, How, where she helps develop and execute litigation strategy, contributes legal analysis and drafting to assist state and grassroots partners in reaching their policy goals, and provides legal information and training to reproductive rights, health, and justice advocates and activists. Farah continues the work she began in 2016 with the SIA legal team, which joined forces with If, When, How in 2016. Prior to this, Farah worked at National Advocates for Pregnant Women, where she established programs in human rights and birth justice. Her publications for scholarly and popular press address criminalization of pregnancy outcomes, economic coercion in childbirth, obstetric violence, and reproductive issues in pop culture. Farah is a graduate of CUNY Law School. And then we're also joined by Lucía Pizzarossa, an associate and postdoctoral fellow at the O'Neill Institute. She's a prize-winning scholar and has previously consulted on matters of sexual and reproductive rights for UNICEF, United Nations Human Rights Committee members, Women Help Women, RFSU, IPAS, among others. And her brilliant work has been published in many renowned peer-reviewed journals. She holds a PhD in international law from University of Groningen and a Magister Juris from the University of Oxford and an LLB from Universidad de la República in Uruguay. She also holds a postgraduate, lots of university study for Lucía. This is new, I'm learning this myself. A graduate diploma in public policy design and a postgraduate diploma in women's rights from Universidad Austral, Argentina. So we've really structured our conversation today to be really a dialogue. And we hope to have some time at the end for audience members to join in and ask their questions. And I want to start with Joanna. Joanna, your work has spanned human rights law, abortion law in countries all over the world. And so what I wanted to ask you is to give us some high-level framing around self-managed abortion in law, legal risk, criminalization more broadly.
Great. Thanks so much, Patty. And I'll just make sure that you can hear me all right. Yeah, great. So thanks. So I think rather than go high level, I'm going to go to the ground for some framing ideas about legal risk, and particularly to focus on the case of our friend, Justyna Wydrinska, who shared her abortion pills with a woman stranded by pandemic restrictions and who was surviving a violent partner at home. And Justyna, for supporting and aiding this person, is now facing a risk of 3 years imprisonment on a charge of aiding and abetting under the Criminal Code of Poland. And in addition, she's facing a second charge of the possession of unauthorized drugs with the aim of introducing them into the market under the pharmaceutical law of Poland. I want to emphasize that many of the media reports about Justyna's case, they have emphasized the abortion law in Poland as being one of the most restrictive in Europe. And that is absolutely true in this case. But it's also true that Justyna could face the same risk as she does in Poland under most of the most liberal abortion regimes around the world. This is true even of countries with new laws like Ireland, where upon the legalization of abortion, they also created a new specific abortion offense for anyone supplying or procuring any means of abortion outside of the law. And this is also true for Canada, a country that we often emphasize as having no abortion law. But the truth is that abortion pills are prescription medicines, and therefore they're subject to distribution controls under the Food and Drugs Act, which is criminal law. And so this is just the truth of abortion law. I think it's a truth that you see, especially if you study abortion law comparatively. In Americas and in Europe, when abortion was criminalized in the 19th century, what's interesting is that criminalization focused on the abortion trade. You see a lot of that strange language and focus in the statutes around procurement. Well, that's all about the advertising. It's all about access and supply of the means of abortion. And those laws came into force through the advocacy of organized medicine. And organized medicine took a monopoly on the abortion practice through its criminalization. So this means that those laws outlawed abortion as a commercial practice, but they also outlawed abortion as a domestic practice, something that people did in their homes, something that people did with the support of midwives, of neighbors, of friends. So I think that history is really important to remember, that abortion law has always been about who does it, how they do it, where they do it, when and why they do it. And that continues to be true of abortion law today. Like whatever their titles on these laws, they are at root prohibitions. And then they create all these exceptions for state certified people, state certified means, state certified places and reasons to have an abortion. Some are more restrictive, some are more expansive, but the truth is these are all laws of state control. And anyone who acts outside of them without state authorization will be punished. And so when you think about it this way, there's just, of course, an inherent tension between self-managed abortion and abortion law. And I also think it's a reason why sometimes this frame of legal risk might not be all that helpful. And the reason why is because it kind of obscures the truth about abortion law. Think about Justyna's case. It really tends to focus on Justyna's conduct as risky, when the truth was her conduct was anything but risky. She wouldn't take the risk of leaving this woman alone. She wouldn't take the risk that woman would be at risk of violence from her partner or be at risk of less safe methods of doing an abortion without information or without support. Those are the true legal risks. And they're legal risks because those are the risks to health and life that the law creates. So I think Justyna's case is so important for us on this point. She makes this point in her own defense. She says, if it is lawful to self-manage your abortion in Poland, then it has to be lawful, to have aid and care in doing so. How can it be a crime for someone to comfort you and keep you safe? Wouldn't you do the same thing if someone asked you for help? And I think it's because she's asked those questions and she's done it publicly and openly that is why the law has been brought down on her. Because that's also the truth of abortion law. It's a history of selective enforcement. For so many years, Polish doctors were selectively carrying out abortions in private clinics securely under the law. And so why was Justyna charged? For me, this is not a case about legal risk as much as a case about legal prosecution. I think it's because self-managed abortion activists like Justyna, they are publicly challenging state authority, and that puts them at legal risk. I think it's the publicness of her actions. It's her claim to a public morality of abortion aid and abortion access that is different than state control that has put her at risk. And so all to say, and maybe I'll stop here, just to say that as much as we think about the mitigation of risk and the protection from risk, I think it's really important for us to ask, why do activists take the risk? And why do they take that risk over and over again? Thanks.
Thanks so much for that, Joanna, for putting it in those terms. I think I agree with you that it's really important, and appreciate thinking about that and starting with Justyna, really the reality of what's happening. I'd like to turn it over to Lucía now. Lucía, you've been working around the world in several different countries to understand how abortion laws pose risk to those self-managing their abortions and people who support them too. Could you share with us some of your findings of that work?
Absolutely. Can you hear me well?
Yes. Mm-hmm.
Yeah. Okay. Perfect. So thank you so much, Patty, for the question, and to Joanna also for introducing this, I think, different framework for thinking about legal risk. And I kind of like wanted to also touch on this matter that Joanna mentioned. It's like the fact that we did this mapping of all the laws. I mean, the recently reformed laws across the world on abortion, and we found that these laws are not really in line with public health evidence. They are not in line with international human rights standards. We have moved quite a while from this traditional medical legal framework of abortion that does a sort of like legalization, still retaining criminal provisions, and still thinking of the clinical setting and the supervision of a doctor as like the ideal setting in which abortions can happen. And as Joanna mentioned, but also like as many of the research that has been done on self-managed abortion, they, like organizations, feminist collective, hotlines, etc., continue to prove that high quality abortions are happening outside of institutional frameworks, and incredibly violent abortions and unsafe abortions are happening within the provisions of the law and within institutional settings, right? So I think this is something that is really important that I will put into this analysis. And I completely agree with what Joanna was saying also about like there's the laws that are in place, most of them, even the recently reformed ones, and even the recently reformed ones in countries in which self-managed abortion has been absolutely fundamental and essential to making abortion safer and to making abortion a matter of public discussion, a matter of democracy, a matter of like really making abortion part of like a broader social justice agenda. Even in those countries in which feminist collectives have been at the forefront of the abortion struggle, the recently adopted laws still maintain some sort of criminalization in different forms, of course, but I mean, some sort of like crime that what the intention is to persecute those who provide support, provide information, provide any sort of accompaniment to the abortion process. So it is really in a way, puzzling, but not really, because we know the political motivations of the criminalization of abortion. But it is really puzzling to see that those who are at the forefront of the struggle, those who are the ones leading the change, that are taking matters in their own hand, irrespective of the legal framework, are the ones being criminalized once the laws are being liberalized, right? So it is really interesting to see, to kind of like see this desire to continue to criminalize those who support abortion, and that enable safer and more dignified abortion trajectories, right? And I think the case of Justina is really interesting, because when we talk about legal risks and we talk about risks in general that are facing human rights defenders and women's rights defenders particularly, we are thinking that the legal risks that they face are not exclusively, first of all, legal, and second of all, related to abortion laws. The case of Justina is a very good example of politically motivated prosecutors analyzing the array of laws that they can use to somehow convert this act of radical empathy and this act of activism and this act of basically being a guarantor of the right of health of this person, right, into a crime. And they are using, for example, laws related to very outdated laws related to medicine, for example, right? Like the introduction of a dangerous, not unregulated or like unregistered drug into the market. And the drug that was introduced into the market is misoprostol. Misoprostol is in the WHO essential medicines list since 2015. It has considered a drug that is incredibly safe, right, for decades, and still we retain this outdated medical and regulations that kind of like gatekeep access to these life-saving medicines. And then the other thing that I think is really important to grapple with is like there are politically motivated prosecutors that are searching for any, let's say, like any possibility to persecute them. And we think about criminalization in a way, so like laws that have criminal provisions, right, that have to do with the use, dispense, and so on of medicines, but also other forms. Like in Argentina, the research that researchers did in terms of like who and how abortion gets criminalized was showing that actually the prosecutors were not really using abortion provisions, but rather were using like homicide provisions or in like other types of crimes that in the end had like a much harsher sentence. So basically criminalizing obstetric emergencies, right, with figures such as homicide instead of abortion. And this punitivism also has to do with like a shrinking space of civil society, right? In some countries in Africa, we have seen that the misuse of, for example, charity statutes or laws that have to do with the registration of NGOs to basically close any like NGOs related to the word of abortion, even if they have the word of abortion in their statutes, or like basically raiding charities that are somehow related to the provision of information or access to abortion services. So what my invitation here is to think about legal risks way beyond abortion laws, which I think is something that we need to start taking a bit more seriously in doing the research also on this to try to understand how are other areas of the law, medicine law, like regulation, import, export of drugs law, etc., to like really persecute and criminalize this kind of activism. I think I'm a little bit in time, so I kind of like want to wrap it up there.
Great, thanks, Lucía. It strikes me the commonalities across countries. It's really amazing and wonderful to bring all these different perspectives together. So Farah, I'm so glad you're here to talk about the U.S. Your organization has providing has been providing criminal defense and legal advice for several years, including in the area of self-managed abortion and criminalization of self-managed abortion, which has taken place. I understand you did, or I'm very familiar with your research on criminalization from the year 2000 on. So you could share with us some of your key findings and what you've learned.
Yeah, thank you so much for the introduction. I really appreciate getting to be in this space with all of you today, especially folks whose work I appreciate and rely on in so many ways. And hearing the resonance between what is happening elsewhere and what is happening in the United States I feel very fortunate to be able to pick up that piece of the conversation. So as Patty mentioned, I work with IFWA now, lawyering for reproductive justice. The entire arc of my career as a lawyer has been defending people who've been criminally prosecuted for the outcomes of pregnancies. And so that might feel a little bit incongruous for folks who are sort of aware of US abortion law. It may come as a surprise to hear that people have been criminally prosecuted for having abortions, for self-managing abortions prior to the Dobbs decision. So the very briefest of primers of what that decision did, the Supreme Court in Dobbs overturned Roe versus Wade and its line of cases, saying they were egregiously wrong when decided, and thus stripping constitutional protections from the right to seek an abortion in the United States, essentially saying that the law, or that right doesn't exist and it's never existed. So that essentially upended the entire constitutional framework for protection for the right to abortion, and triggered a race to the bottom among states to try to restrict abortion in as many ways as possible, because essentially the court has said that there is virtually going to be no review of whether or not the restrictions sufficiently protect people's rights to autonomy and medical decision making, gender equality, all of these things. The court essentially said none of that. What it did not do, so that's what the decision did. What it didn't do was criminalize people who have self-managed abortions. And in fact, the Roe decision never spoke to the legality of self-managed abortion. And if anything, it mentioned that even at the time in 1973, prior to that, dating back to the common law in the United States, generally where abortion was criminalized, it was, as Professor Erdman said, the criminalization of something that one person did to the body of another person, not something that a person did to their own body. So in US jurisdictions, it has always been the rarer case that it is a crime for somebody to end their own pregnancy. That being said, one of the things that has not changed under Dobbs, under Roe, is that people have been criminally prosecuted for self-managing their abortions and for supporting other people in doing so. And so we provide legal assistance in those cases, legal referrals. We provide legal information through our Repro legal helpline. So have been in direct contact with what that looks like for a long time, and do so now into the present day. And I think that, if you pay attention to the political ads that you see in the United States, you might get a picture that the criminalization of abortion looks like, middle-class white women who use abortion pills early in their pregnancy and are hauled off from their kitchen table. There have been some truly dismaying, but also hilarious political ads about what the criminalization of abortion looks like. And I'm here to say from experience and from our research that is not what the criminalization of abortion looks like. The criminalization of abortion looks exactly like the criminalization of everything else in the United States. It is racially disproportionate. People in poverty are disproportionately affected. We recently published some preliminary findings from a multi-year research study. I would like to credit my primary author and best thought partner in the world, Laura Huss, who led the research, which is available on our website. I'll drop it in the chat, called Self-Care Criminalized, in which we looked at every instance we could find of somebody criminalized either for self-managing an abortion or for assisting somebody in doing so from the year 2000 to 2020. That's when our data set closed, and we're tracking in real time as these continue. And so I want to talk a little bit about what the charges are, who are the accused, and what are the types of evidence that are used? Because these things, again, this is new territory in some ways for a lot of folks in the US who haven't been attuned to the possibility that abortion could be criminalized. So first, in terms of what the charges are, I think that one might think that the charge is abortion, but as I mentioned before, generally the crime that is used, when abortion is defined as a crime. It's something that one person does to another person. So that's typically not the charge that's used against somebody who self-manages an abortion. Consistent with what Lucía said earlier about what was transpiring in Argentina, certainly what we've seen in other places, El Salvador, Mexico, that people are charged with homicide offenses. Frequently charges around homicide offenses, improper handling of remains, concealment of birth, which is a sort of 19th century offense intended to punish out of wedlock births, and other various offenses. Very infrequently did we see anything using drug control laws. Usually the focus of the charges, or sort of the gravamen of it, was around the harm to the fetus. And one important finding in all of this, so among the 61 cases that we found of people who were criminally prosecuted for ending a pregnancy or helping somebody else do so, 43% of them, there was a mention of a consideration of a homicide charge, whether or not a homicide charge actually transpired. And within that, it was twice as likely for a person of color to have the charge that was going to be brought against them to be a homicide. So I guess put another way, it was much more likely that a person of color who presented with an obstetric emergency or who had self-managed an abortion to be labeled by the state as a murderer for having done so. The good news is that those charges have typically not been successful, and the outcomes of the cases, I think that we saw, they certainly skewed towards plea agreements, which is very common in the United States, but is a little bit tricky when the charges that are filed against people are often crimes that don't exist or crimes that do not apply to individuals. So certainly here in the United States, we've seen things like people being charged with homicide offenses, even when the homicide offense says that it can't be applied against an individual for an act or omission against their own pregnancy. So what that means is that the perverse incentives within the criminal legal system lead people to take guilty pleas to crimes that don't exist. In terms of who are the accused, again, no surprises here. So 43% of people, or I'm sorry, yes, 43% of the people who were criminally prosecuted were minoritized racial identities. So people of color are disproportionately affected by criminalization, as were low-income people. And then additionally, the vast majority of people who faced criminalization for self-managing an abortion were people who were self-managing in the second and third trimesters. So, and this, as a practical reality, the people who were most likely to experience a complication that would put them into contact with healthcare systems, and people who were most likely to have fetal remains that could be found by somebody else. Then this point of contact between the individual and the health system is an enormous point of vulnerability. 45% of people in the sample who faced criminal prosecution, their case was triggered by somebody in a care work relationship to them. So doctors, nurses, social workers, people with a status as mandatory reporters, even though mandatory reporting laws in the United States do not require reporting of self-managed abortion in any state that we know of, because they are trained to sort of report first and ask questions later, or may wrongly have trust that the criminal legal system is equipped to sort these things out. Then that means that people were exposed to great harms unnecessarily, and very often much to the chagrin of the healthcare providers, who had no idea, exactly where this case was going to go. And then in terms of what the evidence is, so I think people are rightly concerned about data privacy and information, the way that our personal health data are stored, kept, sold. People are right to be concerned about this, certainly. But the evidence that tends to be used against people in criminal cases in the United States is a lot sort of more quotidian in its just how it arises. So to the extent that people had things used against them, like their text messages on Facebook, other sorts of digital information, it was usually after a criminal proceeding had already started, that the individuals, their actual, their physical devices were taken, and then information that was on the device was used against them. So we haven't thus far seen things like law enforcement prospecting, people who are searching for particular terms, use of period checkers, like that is not something that has come up in any cases. Mostly the biggest threat to individuals who self-manage their abortions that leads to criminalization is betrayal of trust by other people. So whether that is a healthcare provider who turns them into law enforcement unnecessarily, or somebody else who turns them over to police. So I'm going to wrap up this part of my remarks just by saying, what we aim to do is not just to assist people who are caught in the criminal legal system, but to ensure that the law is such that they never end up there in the first place. So we seek to repeal harmful laws that can be used to criminalize people, reform laws that have been misused in the past to criminalize people for self-managing their abortions, and reinforce the boundaries of the law. And so what this means is trying to ensure that any protections that are placed in the law for abortion rights are broad enough to encompass it's explicitly prohibit the criminalization of people who self-manage their abortions, because as both Lucía and Joanna earlier said, the liberalization of abortion laws has often left people behind, and we want to be explicit that there will be no criminalization. And this has to be broad enough to encompass any of the charges, the different types of charges that we've seen brought against people for self-managing their abortions, but it also has to apply across the entire spectrum of pregnancy. I think one tendency that we've seen is for people to have discomfort around later abortion and to try to place gestational limits. And the idea of gestational limits, is something that we're importing from clinic-based abortion. It simply doesn't apply when we're talking about acts a person takes upon their own body. Because if we say that there's a gestational limit on the non-criminalization of self-managed abortion, then we're saying that there is a certain class of people who should be criminalized for adverse birth and pregnancy outcomes, and that's simply not compatible with reproductive justice. And the last piece is to reinforce the limits of state power. I think that's the tricky dance that we're having to do in the United States right now, to say that even though the Supreme Court has stripped constitutional protections from abortion rights, that does not automatically translate into the state having power over the individual's person, and to be able to, incarcerate them and deprive them of their liberty for the outcome of a pregnancy. So with that, I will pass it back. But
yeah, well, you can stay with us, Farah, for the next question. And for our audience, I have another set of questions for all of our panelists, and then I think we'll have time to turn to you. So if you have questions as we're speaking, you can put them in the Q&A, and we'll get to as many as we can. So one kind of common thread throughout all the panelists is that there are a range of laws being used to criminalize, or that prosecutors and police are using to inflict harm, criminal harm, upon people who self-manage abortion and people who help them. So it's not necessarily the abortion bans that are going to change the law under which people are criminalized. But here we are in the United States with the growing number of abortion bans. When the dust is settled, around half the states in the US may well have abortion bans, which is likely to lead, and we have research that shows this, restrictions correlated with increase in self-managed abortion. So Farah, I'd like to invite you just to kind of reflect on what the Dobbs decision means for self-managed abortion and criminalization here in the US.
Yeah, so I think there's what it means legally and what it means practically. So what it means legally, as I said before, the Dobbs decision did not criminalize or automatically render illegal abortions, right? Like that's now something that has been kicked to the states. And when we're talking about the criminalization of self-managed abortion, there are only 2 US states that still have a crime on the books specific to self-managed abortion, and that's South Carolina and Nevada. I think the primary concern that we have is one that is more sort of atmospheric, that as there is an increase in scrutiny and additional stigma around abortion, that means that people who self-manage abortions or people who just experience obstetric emergencies are going to be sort of cast in more suspicion. And, as I mentioned before, very frequently the laws that are used to prosecute people are not ones that were intended to prosecute self-managed abortion. It's a matter of a prosecutor deciding that they want to go after somebody and sort of finding whatever they can that's going to stick. And so those prosecutions themselves are driven less by the law than they are by abortion stigma. And so, what the Dobbs decision has done is really intensify this abortion stigma. And I think that also historically in the United States prior to Roe, so the individual who self-managed an abortion, or an individual who had an abortion that was not considered lawful, was not the subject of the criminal investigation, but they ended up being part of the criminal investigation. Their testimony, their health records, like all of these things become a part of a criminal investigation against somebody else. And this in and of itself is harmful. So, it's not enough to say that it's not a crime for a person to self-manage an abortion. When abortion itself is criminalized, people who have abortions, irrespective of how that happens, they become, targets of state interrogations and all of these things. And you can look back through the records, and it's replete with instances of people who are subject to bedside interrogations, have basically their private lives turned inside out in the name of prosecuting somebody else, not even themselves. So certainly that is a concern. At this moment, and just like sitting here today, maybe things will be different in 2 weeks. We're not really seeing a groundswell of effort around laws that will criminalize individuals for self-managing abortions. I think that is still politically untenable. And to the extent that anybody has tried it, there has been swift and immediate blowback. And that's sort of across the political spectrum. And the crumbling of our democratic institutions and, intense gerrymandering and all that mean that that's not necessarily a political reality that we can expect to continue forever. But I think that it does pose an advantage right now for us to aggressively move decriminalization in every place possible. So I see one of the questions in the chat, is decriminalization the answer, or do we need more protective laws? And at least in the United States, the answer is both, right? There need to be laws. There needs to be the removal of criminal laws. I think I would advocate the removal of all laws that are specific to abortion, because there's no need to restrict abortion in any way, any different from any other type of healthcare. But certainly removing abortion from penal codes in its entirety. But I think that as individual states are articulating their protections for people's reproductive health, that has to include a freedom from violence from the state. And I think that affirming that right, that not only does a person have a right to an abortion, to make decisions about their healthcare, make decisions about birthing and all that has to include freedom from state interference, whether that is from the criminal legal system, from the family regulation system, immigration, or other penalties. And we've seen success in creating these types of laws. So recently, California passed AB 2223, which is a law that prohibits criminalization. It affirms a right to reproductive freedom that includes being free from criminalization by the state, and actually provides a civil cause of action in the event that somebody is wrongly, they're subjected to penalties for reproductive decision making. Voters also just passed a constitutional amendment in Michigan that contains similar protections against criminalization. So I think the answer is both. We have to be doing everything, all of it, all at the same time, because we've shattered the sort of basic protections that we had under Roe and its line of cases. I think I'm at the end of my time.
Thanks so much, Farah, for that bit of a look ahead, and a lot is unknown in our volatile political environment. Lucy, I want to invite you back. You as a self-managed abortion activist, you've supported self-managed abortion activists throughout the world. I wonder if you could kind of talk about the ways that activists have approached legal risk in different contexts.
Thank you so much, Patty. And if you ask me how have they approached legal risk, I would say heads on. I think that is something that we can safely say is that without romanticizing activism, of course, because they are increasing threats to the work that these human rights defenders do. They really have approached this with resilience and fierceness and relentlessness. So it is really incredible the work that they have done. And I think it is really important that we also bear in mind that they have been pioneers, this work at the margins of the law, in the gray areas of the law, is the one that has advanced abortion science. The medical development, the scientific developments that we have today have been done in the shoulders, in the backs, with the work of the frontline activists. That is undeniable. The policy making, it has been also advanced by activists, despite the legal risks that they were facing. They continue to develop new and better ways and new and better models of care that are now quite standard. Let's say telemedicine, let's say the recognition of self-management of abortion as an acceptable method for abortion by the WHO. All of that was done because there were activists on the ground developing these like new ways of understanding, studying, regulating, and depicting abortion, right? And even the way we talk about abortion, one of the fundamental things that self-management has done is that to transform abortion from something that is supposed to not happen, something that is negative, something that has to be necessarily a dramatic event of people's lives, to something that is like integral to people's lives, part of their regular, quite ordinary life cycle, and quite a responsible decision in people's reproductive life. So I think like they have dealt with risks quite fiercely, and I think for that is also that a series of scholars, activists, academics, etc., like have also been trying to support the work of people on the ground, and a work that continues to be crucial. And the same way that they approach their work on supporting and providing information, etc., with a lot of creativity, in this same way they have approached the matter of like managing legal risk, right? We have, for example, organizations like Women Help Women, for example, that do a lot of work together and with other movements, the digital defenders and so on, trying to like create intersections across movements, which are extremely important. So because abortion is not a siloed matter, as Farah was very clearly saying, right? Like abortion criminalization follows a pattern in terms of general criminalization in the US, and this is like there are particular communities that are gonna be particularly targeted by the police and so on. And as such, self-managed abortion activists have very clearly understood this. And then, for example, I just wanted to share a couple of things that people are doing in understanding security much more than managing risks. It's like a whole new way of seeing security in a holistic term that includes digital security, but also physical security, also community security. So it's a true understanding of the need to see the complete experience from the person that needs an abortion to the person that's safely self-managed as an abortion, as like, I mean, and further than that, right? But like as a complete experience that we need to take into account in these different levels. And with this, I also want to be very, very clear here in the sense that the self-managed abortion activists have completely challenged the way in which we understand abortion safety. And why do I say this? Because abortion safety is generally understood in a biomedical sense, right? Something that has to do with your health, your physical health, right? And I think self-managed abortion activists have done a fantastic work in showing that safety has to do with protecting a person that needs an abortion in a legally restricted country in their complete trajectory, right? Like understanding that safety, a safe abortion for that person also means safe from stigma, safe from criminalization, safe from the having to disclose this information to somebody that they don't want to, or having to disclose this information to a system and a health system in particular that is quite hostile, as also Farah was flagging, right? So there have been a series of different strategies. I mentioned holistic security, but I also want to mention that there are a lot of manuals to support those who accompany those who support people, right? Like the activists that are doing the work. There are manuals for self-care, there are manuals for self-defense, that collectives have developed in a community way. These are like materials that the community has developed. It's like a bottom-up approach to thinking about security, which I think is absolutely fantastic. There's also a series of networks of lawyers. The Latin Americans have been leading the way on this. They have been working for years already on different strategies to support the activists in the region. But also recently, the Mama Network in Africa also has created its own network of lawyers, to a very large extent, incredibly inspired by the work of Ibn How, with the support of people like that scholars that we have on this call, right, that have been like absolutely fantastic in sharing knowledge, collectivizing knowledge, and really building the movement that will be in the end the one that will respond when these issues happened. And yes, I just want to close here and just to stress that that activists continue to work in the front lines, and they will continue to do so irrespective of the legal risks. And I think it is on us and the ones that work with the law and around the law to try and support that and push for better understandings, better interpretations, and possibly reforms. So thank you.
Thanks for that. I love how that activist work is really changing the way that we think about things in the abortion field, those of us who mostly sit at our desks and think it's so important. So Joanna, I want to invite you to join. Really one of the things I most appreciate about your work is you're constantly challenging us to rethink our current framing. And so what I'd like to ask you to do is kind of look forward to a future. How should lawmakers regulate abortion in order to move forward this project of accommodating people in the way that they have abortions?
Great. I'll be quick, Patty, so we can get in maybe a couple questions, but this one's a good one. Yeah, a good one in thinking about the legal future of self-managed abortion by state action. And so maybe I'll just put 3 possibilities on the table. I think there's the first future of a continuing escalation of the present, more criminalization. And I really like that the panelist Farah mentioned this of increasing and innovative application of new offenses. I think we'll see a lot more drug offenses coming up. But a second possible future would be something we saw during the pandemic, which was that the radical potential of self-managed abortion will be suppressed by state action. And I think this will happen through, for example, the disciplining of self-managed abortion through the controls of abortion law. We saw this in the UK, for example, with the approval of abortion at home with pills. This looked like a really good move. And indeed, it was. It improved access for so many people. But at the same time, they approved the home as a place for abortion care under existing criminal law. They made the reform so that you have to do as little change to the controls of abortion law as possible. It was entirely consistent with the aims of a criminal statute, which, as I mentioned earlier, was the intention to basically push all forms of abortion care, channel them all into a single controlled system of law. That's what those UK approvals did during the pandemic. In this case, against a growing online market of abortion pills with a diversity of platforms to support people to use them. So I have a little bit of a concern about that possible future. It absolutely mitigates risk, but I think it creates its own new order of risk because we know that those legal channels of abortion do not and have not worked for so many people. So then a last third possibility, decriminalization, but also I think indeed, as Lucía said, we have so much research now that shows you when people are informed, when they are resourced and supported, they can safely manage their abortions on their own. And the World Health Organization has now endorsed that view. For the first time in its 2022 guideline, it includes recommendations for self-managed abortion and service delivery approaches to support them. And rather than any single law, the guideline really endorses a policy framework to support a plurality of approaches. So this is just radically different than the abortion laws we've seen in the past. And I can say right now that I have seen no government fully implement these recommendations about, indeed, a positive policy context for self-managing abortion. So last, just to say, it's really important to remember that activists first developed self-managed abortion apart from medical or state authority. And it's because they wanted to break the control systems of law and medicine. They wanted to break the injustice of those systems. So I think law can follow, but in the end, it's really going to be activists who are setting a better future for us. And I think this panel has just made so clear that they are risking so much for that future. Thanks.
Thanks so much, Joanna. That's a wonderful way to end at least this initial Q&A. We do have a few questions, and I want to invite all of the panelists here, and we'll go through them in the order in which we have them. I think, Farah, the first one might be for you. Is in the U.S. context, looking at citizenship under the U.S. Constitution, that we have citizenship status for women, but not for fetuses. And maybe you could to speak to that a little bit, and then maybe I'll open it up to Lucía and Joanna to comment about constitutional protections. And I want to link that to another question I see about the Roe viability standard, which recognized state interest in the fetus, not the right, but a state interest, and sort of constitutionally, how can constitutions, the US and otherwise, deal with state interests in the fetus, if there is one? We'll start with Farah, and then I'll just invite Lucía or Joanna to jump in.
Yeah, so I want to disambiguate a little bit. So the question of these rights isn't predicated on citizenship, it's predicated on personhood. So whether a person has to be born or naturalized a citizen is actually not relevant when we're talking about fetuses. Roe recognized that fetuses are not considered persons under the meaning of the 14th Amendment, but recall it was just overturned. And so, when we're asking about like, why don't restrictions on abortion violate the 14th Amendment? Supreme Court explained it to us. It said that was an ephemeral flash in the pan. That was never a right that existed. This question of, though, I think that there's a good question in there of like, what does it mean to have to balance the rights of one legal person against the rights of another? So the overturn of Roe does not mean that fetuses are now considered legal persons, but we've seen an increasing push in states to create a separate juridical status of a person for fetuses, to treat them as though they have rights that are separate from, and in fact, often adverse to the individual who's carrying that pregnancy. So to go to the other question about the viability standards, certainly that's something that in Roe and in subsequent cases, there has been the notion that the state has an increasing interest in protection of the fetus as the pregnancy progresses for the context of abortion, although in many ways like that has sort of jumped into other areas regarding people's decisions in birth, regarding their use of criminalized drugs and other things like that have allowed I guess, emboldened states to try to criminalize people. But I think it would be a mistake to think that this is just about the viability standard, because the push towards the idea of fetal personhood in US states is actually going much earlier. And there's been an abuse of the term viable to mean that like any pregnancy, any union of a sperm and egg is considered presumptively viable unless the pregnancy is interrupted. So I think that we actually need to look like further upstream as states are now that the Supreme Court has essentially said states can do whatever they want to vindicate their interest in the protection of fetal life. I think we're going to see an increased push in states saying, well, that means all fetal life. That means, embryos. And in fact, there have been statements from law enforcement in some US states saying that the discarding of unused embryos for, fertility treatments and all that could potentially be criminalized because it would be harming an unborn life. So I think that like there is much more there's greater cause for vigilance, that like the viability in many ways like has long been obsolete, but like it doesn't in the context of criminalization of self-managed abortion, that hasn't really mattered. What has mattered is the practical reality of like the visibility of fetal remains.
Thanks, Farah. Joanna or Lucía, you want to jump in?
Yeah. I was looking at the questions and do we need more global advocacy to improve access to SMA everywhere? Absolutely. I am currently in Thailand, attending the International Conference on Family Planning, and out of the, I think, I don't know, 200, 400 sessions that the conference has, there have been very, very few on abortion. So abortion still is not an integral part of the reproductive justice spectrum that we should be talking about in a family planning conference, and very few panels on abortion and very few panels on self-managed abortion. And so it's like, it's very clear that it is a topic that is out of the agenda for many people. For many people, this is something that is happening at the margins of the basically the topics that are important. So I think, yes, definitely advocacy on managed abortion. And about the areas of public health research, I think there's a lot of really interesting research to do on self-managed abortion. I know that IB's reproductive health is doing some like ground breaking research also in the areas of public health. I think something that I find particularly interesting and important is that self-managed abortion can be done further than the 12 weeks. The 12 weeks. So, and it's something that collectives have shown in various studies, that abortion with strong support of feminist collectives and linkages to the healthcare system can be done like much further than 12 weeks. So I think that is perhaps an area in which we could explore a little bit more evidence. But I would really invite the person asking the question, the colleague asking the question, to also check out the work of IPs, because like they really do incredible work.
So we have three questions basically floating in the air, Joanna. One about constitutions, another about global advocacy, and thirdly about what public health research. So I'll turn it over to you.
Thanks. All right, I'll take public health research. Turn over that card. No, I think that this is a really important question, because the idea is not just to focus on decriminalization, but I think also to focus on meaningful differences between non-criminal abortion policies. In other words, what happens after decriminalization? And we don't do and have enough, I think, public health evidence around what could be policy frames to ensure safe supply and safe use that doesn't rely on the control logics of criminal law. And really, people are doing fantastic work in the drug use context of saying that decriminalization does not necessarily mean everybody is off on their own to fare for themselves, but indeed there are really good models of thinking about a supportive framework rather than a controlling one. And so for me, that's a really interesting and fundamentally different policy context than we've worked in before in abortion. But I think it could be a really quite fruitful place to work. And again, I know we keep emphasizing this, but the fact is, activists have secured safe and meaningful abortion access without using the police powers of law. And there is just such a fundamental lesson in that, not just for activists, but truly for the way in which we organize our social and political life. And I think that's, the message coming so clearly for me from the panel.
Yeah, and it's so funny. Every time I hear Joanna, I'm like, oh, Canada, oh my gosh. Because like in the United States, like I think that the important public health research that really needs to happen is one that is research that supports the dismantling of state control over abortion. And maybe that's where we stop, because like we are so firmly embedded in these punitive logics that essentially like all of our healthcare and everything is just on a razor's edge away from criminalization. So, to the extent that we can remove state control and, the state or healthcare systems as intermediaries and access to care, that is sort of our best mode in a lot of places in the United States. I don't think that is the case across all states. Certainly we have states that are trying to create and implement supportive frameworks. But I think when we've been talking to policy advocates who want to know how they can support self-managed abortion, I think that our simple answer, at least in this moment, is get the state out of it. Like don't try to define self-managed abortion in the code, because what that means is that anybody who is outside of those parameters is now subject to the penal apparatus of the state, which is kind of worse. So yeah, the view from across the border.
Well, we're at time, so I just want to thank you so much, the three of you. I wish we could continue this conversation over dinner. That's just my little fantasy over here, but that's not going to happen. Maybe one day. Really so much to think about from so many different corners of the earth, and a lot of commonalities, particularly in appreciating the work of activists and getting us all to where we are right now. So thank you very much. Heidi has put the link to the previous sessions in the chat, and then this recording will be there very soon. So please share with friends and colleagues who aren't able to come, and appreciate you all so much. And stay tuned for the next one in early next year. Thanks. Bye.